Hey guys, welcome back to the channel. This is the House of Law and I'm Attorney Aljabrani, and it's super init today, guys. I feel like I'm inside a toaster. Okay, I hope you're all fine there. So welcome back to a new video. Well, yesterday, one headline caught my attention. Of course, there are so many news and headlines that catch our attention, depending on what you're reading or where you're getting your news from. So I was in Baras Rizal yesterday, to file this civil case for injunction and damages. At tagal ko doon, 4 na oras ata. Nakapag-TikTok pa nga ako eh. Anyway, the biggest news yesterday in the legal community was the Supreme Court press briefer on the decision in Tan-Andal versus Andal. Tan-Andal versus Andal is an action for nullity of marriage on the ground of psychological incapacity under Article 36 of the Family Code. For those who are not familiar with psychological incapacity, it has been defined as a mental illness that leads to an inability to comply with or comprehend essential marital obligations. So said the Supreme Court through Supreme Court Justice Marvic Leonen in Tani de la Fuente versus de la Fuente, GR number 188400, March 8, 2017. Coincidentally, the decision in Tan-Andal versus Andal was also written by Justice Leonen. So did he reiterate what he said in Tani de la Fuente versus de la Fuente? Well, let's find out. So here was yesterday's press briefer of the Supreme Court. Quote, during the en banc deliberation on Tuesday, May 11, 2021, the court in the case of Tan-Andal versus Andal, GR number 196359, unanimously modified the interpretation of the requirements of psychological incapacity as a ground for declaration of nullity of marriage found in Article 36 of the Family Code. The court pronounced that psychological incapacity is not a medical but a legal concept. It refers to a personal condition that prevents a spouse to comply with fundamental marital obligations only in relation to a specific partner that may exist at the time of the marriage but may have revealed through behavior subsequent to the ceremonies. It need not be a mental or personality disorder. It need not be a permanent and incurable condition. Therefore, the testimony of a psychologist or psychiatrist is not mandatory in all cases. The totality of the evidence must show clear and convincing evidence to cause the declaration of nullity of marriage. Justice Marvic MVF Leonen was the ponente of the unanimous decision. Several concurring opinions were also submitted. The full opinion will be uploaded to the SC website once the PIO receives an official copy. End of quote. So guys, why is this big news? Well, the decision has not been officially released yet, but the press briefer is already making us doubt what we know about psychological incapacity, particularly on the requisites and evidence to prove psychological incapacity. Before yesterday, what we know as elements of psychological incapacity are gravity, meaning the illness must be grave enough to prevent the party from assuming the essential marital obligations. Next, juridical antecedents, meaning the incapacity must be existing at the time of the celebration of the marriage. And lastly, incurability, meaning it must be permanent and medically incurable. Also, with respect to the need for an expert witness, it was held in Ngote versus Ute, GR number 161793, February 13, 2009, that, quote, opinions of experts like psychologists are important evidence and carries weight and may in some cases be decisive in a case. The actual medical examination should be dispensed with only if the totality of evidence presented is enough to support a finding of psychological incapacity. End of quote. So, what are the significant portions of the press briefer that are changing what we know then, meaning what we know until yesterday? Well, first, the Supreme Court defines psychological incapacity now as a personal condition that prevents a spouse to comply with fundamental marital obligations only in relation to a specific partner that may exist at the time of the marriage but may have revealed through behavior subsequent to the ceremonies. Second, the Supreme Court said it need not be a mental or personality disorder. Third, the Supreme Court said it need not be a permanent and incurable condition. And fourth, according to the Supreme Court, the testimony of psychologist or psychiatrist is not mandatory. So here are my questions. Una, Dahil hindi na mental or personality disorder or illness ang psychological incapacity, pwede na bang conscious and deliberate inability or refusal to perform the essential marital obligations? Pangalawa, dahil hindi na kailangang permanent and incurable condition, pwede na ba yung temporary, fleeting, and treatable, even preventable kung ano man yung dahilan why the spouse is unable to perform the essential marital obligations? Pwede na ba yung incompatibility due to irreconcilable differences? Pangatlo, dahil hindi kailangan ang testimony ng psychologist or psychiatrist, pwede na ba ang testimony ng petitioner, his or her witnesses, and the legal theories and arguments of the passionate lawyers? Paano na lang kung biased ang judge kasi meron din siyang personal stand on the sanctity of marriage? Dahil hindi na medicine or science ang basihan, opinion na ba ang magiging basihan? Now, the problem with that press briefer, with all due respect, is that it prematurely announced the conclusions without the factual context. Parang nagsabi na lang na ito ang sakit at ito ang treatment na kailangan ng pasyente without stating kung ano ang symptoms. That's why everyone's debating about it. This is the reason why we should wait for the full text of the decision in Tan-Andal versus Andal so that we can understand the context by which these conclusions were made. Remember, the rules on psychological incapacity were never cast in stone. Kaya paiba-iba ang ruling ng mga lower courts, Court of Appeals, and Supreme Court. And because the rules are not fixed, the personal beliefs and biases of the parties, lawyers, the public, and even judges can come into play every time the issue arises. But I agree with a lot of the comments that this is good for those who have been languishing in failed marriages for years. If indeed the psychological incapacity need not be medical, mental, or personal disorder, but a legal condition, meaning a legal conclusion only inferred from a certain set of facts, then we are making it easy for these aggrieved spouses to free themselves from the shackles of a failed marriage. Now, do the conservatives have to worry? I don't think so. The concept of marriage is not being attacked. It still remains to be one of the greatest unions and miracles of life. It is still the path to a blissful and lasting conjugal and family life. So anyone who's married and happy will prove true the ideals of the conservatives. Emphasis on anyone who's married and happy. But marriage is not for everyone. Just like pizza with pineapple is not for everybody. So conservatives or liberals alike should just agree that if the marriage is no longer serving its purpose of establishing a blissful and lasting conjugal and family life, then let the spouses free and let them redeem whatever remains of their sanity, their self-respect, and their productive lives. That's just my opinion, I guess. But maybe true. Now, if you agree, please drop a like. If you don't agree, let me know in the comment section below. If you're new to the channel, please subscribe. Please click that notification bell if you want to see more videos like this and of course my lecture videos. Now, para hindi lang din kayo ang nakikinig at nanonood ng mga videos ko, please share nyo na rin ang mga videos ko. Okay? So, I'll see you in my next video, guys. Laging tatandaan, isip ay buksan, alamin ang batas. Bye, guys!